Across America, BP supports more than 275,000 jobs to keep energy flowing. Jobs like building grid-scale solar energy in Ohio and producing gas with fewer operational emissions in Texas. It's and, not or. See what doing both means for energy nationwide at bp.com/investing in America.
Have you heard? You can listen to your gripping investigations ad-free. Good news. With Amazon Music, you have access to the largest catalog of ad-free top podcasts included with your Prime membership. To start listening, download the Amazon Music app or visit amazon.com/truecrime ad-free. That's amazon.com/truecrime ad-free. And catch up on the latest episodes without the ads.
Content warning, this episode contains discussion of the murder of 2 girls, as well as the sexual assault of a child and inappropriate language.
So, of course, as we all know, Richard Allen has a couple of matters before the Supreme Court of Indiana, and there's been some activity on those fronts this past week, the most important of which is probably the fact that Judge Gull filed a response brief in the first of the 2 cases. So we're going to get into all of that in this episode and discuss it and try to explain what we make of it. Before we do, I think it's important to say here at the outset that one thing I hope we can agree on is that there are reasonable people on both sides of this. I think earlier we did an episode with Brett Nallis from the prosecutors where they discussed the view from the prosecution side. Earlier this week, we also did an episode with Shay Hughes, the Hoosier public defender. He explained rather well, I thought, how things looked from the defense side. And I'm emphasizing this because there's been a lot of heated rhetoric out there suggesting that the courts are somehow corrupt or there's something wrong with the process or the system. And during this period where we don't know how the Indiana Supreme Court is going to rule, I hope we can all agree that no matter how they rule, the ruling will be legitimate and that should be the end of the matter. And that a bunch of talk about illegitimacy, the courts being corrupt or overrun by odinous or whatever you think, that really isn't helpful.
No, it's not helpful at all. And frankly, it's irresponsible when you have people going around saying that with zero evidence other than things are happening that they don't want to happen. It's not ever based on any sort of like legal analysis that's cogent. It's vibes. I got a bad vibe from this, so it's corrupt. That's not how this works. And kind of basically giving air to people like that is just also terribly irresponsible, in my opinion.
It's heated rhetoric, wrong rhetoric. A lot of the people out there saying this sort of thing are also stating facts that are just simply wrong. And again, I hope we can all just accept the Supreme Court of Indiana's rulings, whether we personally agree with those rulings or not. Hopefully we can accept them and move on. With that said, as I indicated, we're going to be discussing the recent developments in these Supreme Court cases.
My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is the Delphi murders. Richard Allen goes to the Indiana Supreme Court. Judge Frances Gull responds.
So again, there are basically two different Supreme Court cases involving Richard Allen at this point. The first one revolves around record-keeping issues, and the second revolves around whether or not Judge Gull should continue with the case, whether or not defense attorneys Baldwin and Rosie should come back to the case. And so today we are going to be discussing the first one. We're going to be discussing the one involving records.
And may I say that these two cases, it's very important to draw these distinctions because to me, in my mind, it's sort of like the first one about the record keeping includes a lot of reasonable filings and sort of discussion of more transparency, more public transparency in this case. And the other one wants Judge Gull to be forced off the case and original attorneys Andrew Baldwin and Bradley Rosie reinstated. Everyone we've talked to behind the scenes about this has essentially felt that the first one was a little bit more likely to result in some changes than the second writ, I think is putting it mildly.
But we'll see what happens.
But it's important when we're talking, people conflate these two things, and it's really important. These are separate cases right now, and there could be different rulings on each one.
Exactly. So the first activity was earlier this week on November 14th. Judge Gull actually made an order in the actual criminal case involving Richard Allen. This is the case he's on trial for in Carroll County, where obviously I'm going to wildly paraphrase here, but essentially she said, the people in the Supreme Court writ, they asked for a bunch of records to be released, filings to be restored. Let's go ahead and restore all those filings. So basically she gives them almost everything they asked for in the order, except for they want the Franks memorandum to be made publicly available on the My Case website. She says, I'm not going to do that because there's stuff in there that shouldn't be included in a court filing. If you want it to be made public via the court system, you need to make some redactions. But other than that, it's almost like a surrender.
Is it a surrender or is it a strategic retreat? That would be my question.
I'd say potato. It's like a you can't fire me, I quit situation.
Right. But does this defang to a certain extent the writ?
Certainly we will see that her attorneys make that argument, and we'll discuss that shortly. There's also a brief file this week which responds to that argument. Well, I guess since we're raising it now, why don't we just go ahead and discuss it?
Yeah, let's jump into that.
A group of media organizations filed a brief.
Yeah, the Indiana Broadcasters Association, which I'll just say includes the Hoosier State Press Association, ABC, WRTV, the Indianapolis Star, WXIN/WTTV, WTHR, and they're represented by several attorneys from Denton's Bingham Greenbaum, including Margaret Christensen, Daniel Byron, Scott Leiss, and Jessica Lauren Meek.
So we would talk more about this brief later. Since it came up, I just want to talk about one very small part of the brief, where they say, the fact that Judge Gull ordered these documents to be released, people could say, well, that means this writ isn't necessary. But we still think it is, because if she orders it released, basically she's doing that out of the kindness of her heart. And she's not doing it because she's following court procedure. She's not following court orders. We want there to be a court order in place to mandate basically that this is what happens going forward.
Yeah, so they're saying this situation, her release of these documents, is dealing with the present. We're looking at the future of the case. So that's their argument. Makes sense to me.
It makes sense to me, and Judge Gull in her brief says, well, we don't need this writ because I already took care of it. It's all moot. Here at the Murder Sheet, we work on the podcast and our investigative reporting full time. That means we sometimes don't have time to meticulously plan and cook delicious and nutritious meals. So, in this new year, we are eternally grateful to our sponsor, Factor.
Now's a great time to try out ready-to-eat meal delivery service Factor. Remember, when you support our great sponsors like Factor, you're supporting us and our ability to keep doing this work. So please consider visiting factormeals.com/msheet50 and use code msheet50 to get 50% off.
Factor allows you to pop your ready-made meal into the microwave. In 2 minutes flat, you'll have a hot and ready dish with minimal cleanup afterward. It's just that simple.
Also, this food is awesome. I recently dug their black bean and rice enchilada bowl with roasted zucchini, corn, and salsa verde. It tasted so fresh and flavorful.
I love that we get to skip meal prep, the grocery stores, expensive to-go orders, and elaborate cleanup. Plus, there's plenty of options for extra picky eaters like me.
We've really been thrilled with Factor, and we feel you will be too if you're striving to eat healthy and save time in 2024. It's really helped me meet my nutritional goals for the new year.
Head to factormeals.com/msheet50 and use code msheet50 to get 50% off. That's code msheet50 at factormeals.com/msheet50 to get 50% off. As a part of this, a couple of documents she ordered to go ahead and be released that had previously been sealed. Why don't you tell us about those documents?
Well, they both had something to do with a man named Robert Paul Baston, and he is currently incarcerated at Westville, where Richard Allen is incarcerated, and he has sort of inserted himself into this case in a way, and I want to get into his background as well as what his role in the current proceedings are.
And we'll discuss his allegations and what's related in these documents, certainly.
Yes. So should I start off by talking about what he was charged and convicted with?
Sure. Who is this guy?
So this man, on August 16th, 2009, his mother threw a pool party at her house, and a number of people were over. He lived with his mother. And a 6-year-old girl, who the court documents just refer to as AP, was there along with her father. So Baston was convicted of taking this 6-year-old from his mother's house, driving her on a 4-wheel vehicle to a undeveloped area, sort of out of sight of everyone else. And I'm going to read this is from a May 27th, 2011 memorandum decision regarding an appeal from the Ripley Circuit Court that gets into what he did to her. And keep in mind that this is graphic, but I think it's important to not look away from this. And, if you want to skip ahead a few minutes, go ahead. Baston stopped the vehicle and pulled the crotch of AP's swimsuit to the side and performed oral sex on her genital area. Baston then put AP on the ground and, as AP later explained, rubbed his private on my private. AP stated that this caused her pain and soap came out of Baston's penis. After he was finished molesting AP, Baston placed the child back on his vehicle and drove her back to the party. Meanwhile, AP's father and other adults were looking for AP after noticing that she was missing. When AP saw her father, she got off Baston's vehicle and began to cry. She told her father that Baston had touched her pee-pee and licked her pee-pee and put his on hers. Baston stated that AP was lying, to which AP responded by pointing her finger at Baston, raising her voice and saying, "Yes, you did. You are a liar." The back of AP's swimsuit was dirty when she returned home. Here's more about the investigation into Baston. AP was later taken to the Cincinnati Children's Hospital, where she was examined. The examination revealed that AP had abrasions on her posterior fourchette and redness in 2 areas near her hymen. Hospital personnel notified the police, who recovered AP's swimsuit. Forensic analysis of the swimsuit revealed that the inside crotch of the swimsuit contained 2 areas of mixed DNA from 2 individuals. In the first area, Baston was the main contributor of DNA and AP was the minor contributor. In the other area, AP was the main contributor of DNA and Baston was the minor contributor. The odds of the DNA matching Baston and also matching another unknown person were 1 in 24 trillion. So you have the victim in this case immediately identifying him. He's seen bringing her back by other witnesses at the party, and his DNA is in the crotch of her swimsuit. So I would say I would characterize this as a pretty good case against this man.
No doubt about it.
Okay. And so I think it's important to kind of dwell upon that and some of what's come later with him. So let's document some of his behavior while incarcerated now.
Certainly.
So he's what they call a prison house lawyer. I think they're often called a jailhouse lawyer, but I'm going to call him prison house because he's in prison. He's in Westville. And he's filed for years numerous handwritten motions that get pretty weird, to be honest. But let's go back into this is something from 2018. This is a motion he filed. Petitioner Robert P. Baston has attempted at every stage to raise the claim of wrongful conviction and incarceration due to a broken justice system. Since incarceration due to prison overcrowding, staff and officer shortage, and state of Indiana budget cuts, the Indiana Department of Corrections cannot keep inmates or staff and officers safe, and therefore violating case laws and Constitution of the state of Indiana and the United States of America. Another claim that he made that I think is worth noting is that, according to him, doctors who examined the 6-year-old child that he molested felt she did not act like a victim, whatever that means.
So basically, he's slut-shaming a 6-year-old girl.
Yes, that he raped.
Yes.
So, yeah.
I think also, before we move on to what he wrote in his letter, it's worth pointing out that at one point during the process, at least at one point in the process, he did have an attorney, and it's an attorney with a familiar name.
Kara Weinecke.
She's one of the attorneys for Richard Allen in this. And what did she represent him on?
This was post-conviction relief, and this occurred in, I believe it was 2018. So she came on, and at this point, the post-conviction relief that he was asking for was pretty bizarre. He was asking to be lethally injected. He wanted to be executed. Now, his was not a death penalty case, but he was effectively saying, to boil it down, I'm so miserable in prison and my rights are so violated here in prison that I just want to die. So the state should just lethally inject me. So she came on board to help him with that, I guess, or help him manage whatever that was. And she kind of went back and forth with him, seemingly with letters. There were some delays because he was, I suppose, moved, and his letters took some time to catch up with him. That was their initial contact. And then later on, there was a petitioner's motion to vacate post-conviction hearing. So Weinecke had investigated some of Baston's claims. They're going back and forth.
And these claims were going to be discussed at a hearing. And she's basically indicating to the court, well, we don't need this hearing. After completion of the investigation, counsel informed client by letter of her remaining findings and opinions regarding the merits of his claims. And after this investigation, which she tells him about the merits of his claims, she's like, let's just vacate the hearing.
Yeah, that seems telling at the very least that his claims did not have the evidence backing them to warrant a hearing. Not saying that she was necessarily skeptical of his claims, but just that they didn't rise to the level of there needs to be a hearing about this. The fact that she went from let's have a hearing to let's not is notable, I think, here.
And do we now discuss let's discuss the fact that earlier there was a letter from him released alleging that Richard Allen was being subject to abuse in prison. And
yes. That was written on filed on April 28th, 2023. And he introduces himself as a inmate at Westville Correctional Facility in the same unit that Richard Allen is being housed in. And he said that he was being abused, and essentially people were telling Allen to kill himself. And he's saying he has proof and evidence of the assaults by different officers. And so it is a 3-page letter that got filed into the court.
You were understandably quite skeptical at that point.
Yeah, I was incredibly skeptical because then I looked up what he was in for. I'm not skeptical of an inmate because they're an inmate. We've had inmates, former inmates, on this program, and I found both of them to be highly credible gentlemen. And just because you are in prison for a crime does not mean that you're lying about abuses and problems that occur within a prison system. We also know that there are abuses and problems that occur in the prison system. So keep in mind that I'm coming from that mindset of let's hear him out. So I'm not reviewing the fact that he was convicted. I'm reviewing the fact that he is a prison house lawyer who has filed garbage filing after garbage filing. I mean, to give you a sense of one of them, he said he should be let out during the COVID pandemic to help fight COVID. What does this man have to offer in the fight against COVID? That's my question. I'm highlighting that because that's stupid. That's a stupid ask. He's not like a good prison house lawyer. He's just has a lot of time on his hands, so he does this. And in addition to that, the fact that he never owned up to his crime, he maintains that.
Let's hit pause there for a second. I think it's also worth noting that one of his own attorneys, Ms. Weinecke, seemed to be skeptical of his claims in another matter after investigating them. So there's some reason to be skeptical of what this gentleman says, but still, things are worth investigating. If a claim is made, there's always at least some sort of possibility that it's true. And so I think let's mention now something I don't think we've mentioned before, that we reached out to this man.
Yes, we did.
And in Indiana, it's actually very easy to reach out to people who are incarcerated. And so we reached out to him and we emailed him. And we actually had several emails back and forth with him. And I want to read an excerpt from the first email we got back from him. I can provide you with a lot of information concerning Richard Allen and his poor treatment, but only if you're going to expose the issues with all inmates and not just Richard Allen. You also may be interested in my case, with DNA contamination in a brand new $70 million Indiana State Police crime lab, and Indiana has a history of contamination in their labs that wrongly convicted and incarcerated people, and town police admitting to destroying evidence in my case and telling someone at hospital to take evidence home with them instead of collecting it like they're trained to do, and a jury that said they did not believe the evidence or the accuser in my case and found me guilty because I looked guilty when juries are to convict on evidence and reasonable doubt, and also 2 different doctors from 2 different hospitals documenting that there was no trauma and the accuser did not act like a victim of sexual assault, and there was no DNA found in the rape kit testing and perjury testimony, coaching and vouching issues, and many other issues in my case that has a truly innocent man wrongly convicted and incarcerated. So I took that to mean basically that he would only provide information about Richard Allen or alleged information about Richard Allen if people helped him with his case.
Classic bait and switch.
He's maintaining there that he is innocent, wrongly convicted. Help me and I'll help you.
So yeah, I guess the Indiana State Police lab actually got to the 6-year-old and had her accuse him, at the party where this happened. So it's fascinating.
It's a ridiculous claim. And this certainly added, I think, to your skepticism and certainly to mine, because it feels like he may be using Richard Allen's case as a vehicle to pursue his own claims about his own case.
Let me just make this very clear, because the media does not care about Robert Baston. The media does not care about his case. He was convicted on good evidence. He went away. He's not going to be eligible to get out until he's like 75. And I think most people say good for that. That's a good outcome in the justice system. Nobody cares about his case. The evidence stacked up against him on all levels, and the only way he can get anyone to care about his case and himself, frankly, and get attention on himself is if he leeches onto a more high-profile case like Richard Allen's. Richard Allen is a tool for this man to hijack some media clicks, and that's just what's happening here. He portrays himself as a whistleblower for prison abuses, but again and again when we contacted him, he made it very clear that he didn't really want to talk about Allen. He wanted to talk about himself.
He'd also say things like he was going to stage a hunger strike to expose wrongdoing. And they said, well, on second thought, I'm not going to do a hunger strike. So he did not seem to us in this back and forth to appear especially credible.
Yeah, and information he gave us about Allen, like he said in April of 2023, Allen spread feces all over himself and all over his cell. That's interesting because it speaks to maybe somebody's mental state or whatnot, but I don't necessarily trust that.
And to be clear, he told us this, I think, in August or September, but he's referring to an incident in April.
Yeah, these messages were all exchanged in August and September, so that's when we were communicating with him. But again, this interesting info there, but I don't trust it because of the source. And you have a guy who's very, very obviously trying to game the system here in order to get media attention and get support. And what is kind of striking to me is that because his letters say some things that people like, i.e. like leading up to a prison conspiracy, people are taking him completely at face value without looking into his background or his other claims or anything else. I think that's a huge mistake. I think context is super important here.
So with all of that said, let's go back to April. He's written a letter to the court alleging abuse. And so the defense wants him to come and potentially either just talk to them or perhaps even offer testimony in the hearing that was held in June. And so the two documents that were recently released were the transport order for Baston from June and a letter from Baston. Why don't you discuss those?
So let's go into the transport order first, I believe, because that would have come first. So you're probably wondering, wait, Baston was supposed to testify? Yes. Did he? No. Why? Well, we have a document signed by Carroll County Sheriff Tony Liggett, where he says that on June 14th, 2023, they were in contact. His department was in contact with Carroll County Sheriff's Special Transport Deputy Brian Wysocki. And Wysocki goes to Westville. He's going to pick up Baston and take him down to Carroll County for this hearing. And Baston refused to leave his cell. In fact, when Wysocki was there, he met a correctional officer who told him that Baston was refusing to come out of his cell and was even shouting things like, "Fuck you, you can't make me go." And there would be, essentially they would have to do a cell extraction, which would be force him out of the cell. And instead of doing that, he called Chief Deputy Tobe Lesenby, and there was kind of phone tag between Lesenby, Gull's office, and Gull ultimately said, leave him there if he doesn't want to attend. Because, and what's interesting to me is that's been widely criticized, but these are also the same people who are seemingly suddenly very concerned with prison inmate rights. And if a person doesn't want to testify, I think dragging them to court in this situation doesn't seem like the most humane mode, in my opinion.
So in his letter, didn't Baston offer some sort of explanation for why he did not want to go to court that day?
Yes. So he writes a letter. This is filed on July 5th, 2023. And he is essentially saying he was in danger for his life. That's why he couldn't.
How so?
Well, he wrote, due to corruption and retaliation by Westville's restrictive housing unit staff and officers, I had to refuse to appear in the above-mentioned court hearing due to my safety and fear for my life. So it's this letter that he's basically claiming that.
So basically he's saying because he has criticism to offer regarding Westville, people at Westville would kill him?
Yeah, they would kill him.
So my question there is, if I had criticism or information that I felt put my life in danger, I feel I would want to share that with the widest number of people as soon as possible, because getting that information out would in some way protect me. He's getting the information out via letters which at this point were still being sealed. So if I was an evil villain twirling my mustache, why not kill him then? Why not kill him when all he's doing is writing letters? Why not try to protect himself by going public and offering testimony? Does that make sense? Does my question make sense?
Yeah, your question makes sense, and this whole thing doesn't make any sense. And frankly, maybe I'd be a little bit more, okay, well, let's hear him out on this particular subject if we hadn't experienced the same thing in August, September, which was, I have information about Alan. I want to expose it. And then you email him, and it's this long, like, single sentence, multi-paragraph mess about how sad his life is.
Because he was wrongfully convicted.
Right. And
he certainly was not wrongfully convicted.
No, he certainly was not. And this is a situation, though. But again, like, it's the same thing. Like, I have something to say. Never mind. Just pay attention to me. Okay. Frankly, I think it was an incredibly desperate move by defense to even want to bring this guy in because of his low credibility. I think that looks really bad. I think in some ways, looking back, it was probably good for Richard Allen that this guy did not come in to testify on his behalf, because I think he has so many problems. It would have just turned into a even further of a circus. You would have had the thing where, oh, wow, this guy seems great. Like, he's saying all the things we want. And then, suddenly he's talking about how he needs to be released so he can stop the COVID pandemic. That's not a good look for Richard Allen's defense or Richard Allen. That's not something you don't want. People who lack credibility to that extent and have a history of these petty grievance filings that, I mean, even his own attorneys kind of end up maybe saying, well, I don't know if we need a hearing for that. So I guess
in fairness, to be completely fair and lean over backwards, from these documents, it's not clear to me if the intention was for Baston to testify that day, or if it was just to have Baston meet with the defense attorneys who were understandably interested in whatever he might have to say.
Yeah. I think he's a person who seems smart enough to dangle Richard Allen to people, whether that's press or Allen's attorneys or whoever. He's not smart enough to play the long game, because immediately once you put eyes on him, once you start talking to him, he switches. It's all about him. And, and Allen becomes just part of the package deal as long as you're doing what I want. It's a very, like, crude manipulative tactic. It's not very effective, but that is what I view this as.
So those were the new documents that were released in accordance with Judge Gull's order at the beginning of the week. Yes. And what do you make of his Baston's role in this? Do you think that this is credible? Do you think that it's good that people are just going based on this man's word alone? He does not seem to me to be a very credible person. And again, I didn't just jump to that conclusion. I reached out to him. We reached out to him. We had a back and forth. I'm curious as to why there's a lot of people out there who are expressing support of Baston or what he says needs to be amplified. And I'm not clear why they haven't reached out to him as we did. Or maybe just read the 2011 memorandum that details what he did and how he's behaved ever since. I think it's important to come to people with skepticism and some open-mindedness. That can be difficult to balance at times. But when I see this level of manipulative tactics from somebody, and again, repeated lies, exaggerations, overstatements about his own case, that undermines credibility, in my view. And I don't think you just have to take somebody's word when there's something like this going on. And I think it's ultimately not great for Allen that people who are allegedly supporting him are trying to hitch their star to this guy's wagon.
because this is not a wagon that's going anywhere, people. This wagon is in the friggin' gutter.
Are we ready to move on?
Yes.
So then, not long after that, as we alluded to earlier in the episode, a group of media organizations, Anya read the list earlier, filed a friend of the court brief in this first case. And again, I want to emphasize the media organizations aren't filing to say Rosie and Baldwin need to come back and Gull should be thrown out. They're filing entirely on the issue of let's have records be kept more openly. Let's have records be more accessible to the public. It was a relatively short brief, but it was concise. I felt it made some very strong arguments. Basically, they made three strong points, and one was the trial court's handling of court records is contrary to Indiana public policy favoring open government and the Indiana and United States Constitution protecting access rights. That basically means that it's important for people to be able to see what their government is doing, including the courts. And the way a lot of these documents have been kept sealed and out of public view impedes that process. We just gave you some of our opinions about the Baston letter, for instance. People should be able to read that letter. People should have been able to read the transport thing and form their own conclusions. There's no reason for a lot of this stuff to have been sealed.
And if for some reason something has to be sealed because either the defense or the prosecution feels it will impede Allen's rights or be too sensitive, then those should be filed alongside motions to seal. There's a process for sealing things. It's not like it's one or the other. It's not a zero-sum game. It's just that typically there should be a process that's followed. And we don't really understand why it wasn't here.
Another point they make is Judge Gull's violations of trial rules significantly undermine the public's access rights and the media's news gathering function. Again, I think that pretty much speaks for itself. The public can't know what's going on. The news media can't report what's going on if virtually every document in a case is sealed.
Yeah.
Yeah, people have the right to know. And their final point was granting this petition to open up the records even more would serve the significant public interest in this case, and denying it would have adverse consequences.
There you go. So they're saying on that first writ of mandamus, they're supporting it. They're looking at the future. They're not just looking at the past. And I mean, yeah, I think they raise some good points. I would hope that the record keeping is better going forward. One thing, if I may just sort of jump off here.
Uh-oh.
I still don't understand how some of these record keeping issues even happened. We've heard from some folks who say that sometimes there can be issues with that because like a special judge is not part of the county where the clerk is operating, and there can be a disconnect there. But I don't know. I wish we had more of a sense of what exactly happened, because I think to the media's point, it shouldn't happen again. But like understanding exactly why, what were the motivations? Were there motivations? Was this just a disconnect between clerk and judge? Were things being purposely put away? Is it a combination of both? Like what exactly was happening? I thought it was interesting because Gull kind of in her response points at the clerk, like it's her responsibility to put some of this out there. But I just don't know. We felt when we were trying to get documents at times that there was kind of a, sort of a pinball thing where we're kind of being hit back and forth between different people, everyone who's acting like they don't know what's going on. And so I would be very curious, like what exactly broke down here.
It'd be nice to know. And maybe if there's more public access to some of these documents, we'd know.
If it's not Judge Gull's fault, if it's essentially the clerk's fault, then I think that should be public too. If it's Judge Gull's fault and not the clerk's fault, we just, I'm not saying we need to scapegoat somebody. I'm just saying it would be
I want to
nice.
find out what happened so we can be ensured it doesn't happen again.
Yes. Or if it's nobody's fault, but it's truly like these documents were put into a no man's land and nobody really complained about it until we did. And then they kind of just made a mistake by, instead of putting it on my case, they just put it all out there. Then that's fine. But we should know about that.
Yeah, Anya and I had to file into the case to ask for these documents to be released, 118 documents. We should not have had to do that. And no one should have to do that again. These documents in this case and in other cases should be public.
So I think I would love to identify where the breakdown is so that there can be an understanding. And then also other cases that maybe have a special judge or maybe are high profile, they can take that and say, oh, here's what happened in the Delphi case. Here's how we can try to avoid that. A learning opportunity, right?
Exactly. So then after that, Judge Gull and her attorney filed their brief in this record-keeping case. And again, this is basically them saying why the Supreme Court doesn't need to issue any rulings or what have you in this particular case. Their arguments can basically be put into two different categories. The first category is procedural stuff. That basically means, well, you shouldn't consider this motion from Richard Allen at all because he didn't file it correctly. He didn't follow the process correctly. So they have some arguments about that. And then the second category is on the substance, where they say, well, you also shouldn't grant it because he's wrong. So let's talk about some of the procedural issues. They say, for instance, that before he filed with the Supreme Court, he should have sought some sort of relief from Judge Gull from the trial court before immediately going to the Supreme Court. They say he has not acted expeditiously. When you file a motion like this, he's supposed to act very quickly. And he's referring to things that happened back in June. It's now November. You can't say you're acting expeditiously about something that happened in June if you're responding to it in November.
Why is expeditiousness important in a court case?
In this court case, you just don't want things to go stale.
And as for the not skipping ahead too far, why is that important? Like, why is it important to kind of go to the appellate court first?
Typically, there's a process to be followed. Go to the trial court, you do these other things. Because let's say, for instance, that we come home tomorrow morning and we see a mouse in our house. Should we then immediately say, okay, that's it. We got to burn the house down. We got to buy a new house.
That's what I would do.
Because there's a mouse. Or would we say, well, how did this mouse get in? Can we call an exterminator? Can we try to catch the mouse?
Can we reason with the mouse?
Before you take the most extraordinary step possible, you're supposed to take smaller steps and follow a process. And if you have a situation where everybody who sees a mouse in their house is immediately burning down their houses, that could be a problem. There's a reason why certain processes have been developed.
Okay, that makes sense.
Let's take care of it at a lower level unless we really can't take care of it at a lower level.
And then escalate it further.
Yes. Gull also argued that Richard Allen did not demonstrate that if this petition was denied, he would suffer any real harm. And she points out that Richard Allen, and his attorneys have access to all of these documents. So how is his interests harmed by the fact that other people don't have access to them?
Okay, that's an interesting point.
What do you think of that point?
Well, I mean, I tend to want the press to be able to have documents, so I don't agree with it. But it's an interesting point because it does also kind of point to the fact that they've been trying this in the press, which is not a statement criticizing them. That is an objective statement of what they have been doing, or at least what the old defense team has been doing. So he's kind of effectively tying himself to that narrative in my mind with saying that.
So then they also move on, as I said, to the second category is that this claim should fail on its merits. Because basically they say, well, earlier this week, Judge Gull told the clerk to make most of this stuff available anyway. So what difference does it make?
It's a moot point, therefore.
I think we discussed that at the top of the episode.
We did, and I'll just say that I actually see her point, and I kind of see why she did that. I tend to hope that, though, there's something that comes out of this that makes that sure that is permanent. Again, whether or not that's Gull's fault that this was happening, ensuring that it is not happening going forward seems very important to me.
They also feel that too much emphasis is placed on whether or not something is available on my case in the public docket, because Judge Gull says something is considered publicly available if you can go to the courthouse and use their computers to access it. That's something that's technically true, but the fact of the matter is there are a lot of people all over the world who are justifiably interested in this case, and it would be a hardship to expect anyone who's interested enough in this case to want to read a court document, to hop on a plane or what have you, fly to Indianapolis, rent a car, drive to the Carroll County Courthouse, and access documents there instead of just doing it from the comfort of their own home via my case.
I completely agree with that on principle. I completely agree with that. But legally, does that matter? Does it matter that it's inconvenient to us?
They're making the argument that it doesn't matter.
Yeah, I kind of feel like it. I agree with you on principle. I don't really. That doesn't sound like that sounds like the courts are not exactly, especially in this state. I feel like often like holding the hands of the public or journalists on this, and I don't think that's good. I think it's good to have things open, but when we're talking about just what the legal ramifications are, I feel like they're going to look at that and say, yeah, that's it. That sounds like a you guys problem rather than an us problem.
That's true. I guess just my personal opinion is our definitions of things like public access should not be written in stone and never change as times change. 20 or 30 years ago, yeah, if something's available at the courthouse, that should count because it was a different time. You didn't have an internet.
So you're not an originalist, Kevin.
Today, public access should be defined as broadly as possible.
I completely agree, but is that in this situation isn't, I guess, like what should be doesn't necessarily seem like to compute much in this situation, I guess. I don't think that's a good thing. I wish that things were different, but I'm just saying, like, when we're thinking about like what the legal outcome of something is going to be, that's what I'm more interested in at this point. I think there should be assigned seating for accredited media institutions and freelancers like ourselves. I think there should be, more access to all these documents, but that hasn't happened so far. So I don't see it happening at this point.
And I want to read you a paragraph from this brief as it relates to the Franks memorandum. As we mentioned, when Judge Gull decided to make a lot of things public, she did not make the Franks memorandum public, even though, of course, anyone can go online and get copies of it.
The horse is out of that barn.
Relator also seeks to unseal or restore public access to the Franks memorandum. The Franks memorandum contains the full first and last names of the deceased minor children who are the crime victims in this case. Names of minor children are required to be redacted from court filings in federal courts. Indiana, in turn, excludes case records declared confidential or excluded from public access pursuant to federal law. Therefore, the Franks memorandum is marked as confidential because counsel failed to supply a redacted version at the time of filing. Respondent has ordered new defense counsel to review the pleadings and either adopt them or make them their own. If counsel adopts them, they are ordered to file a redacted version. So that's a bit of a word salad. It seems to be saying that because Rosie and Baldwin included the full names of Liberty German and Abby Williams in the document. That should be enough for it to be declared confidential. And that's an argument I find interesting, certainly because I'm sure if you go through many other filings in this case, the names of the victims are mentioned. I believe, I'm pretty confident the prosecutors mentioned them in many of his filings. So I just wanted to highlight that, as it seemed like frankly a bit of a bizarre argument. What did you make of it?
I don't get that at all. I think, like, on a sort of outsider's non-legal perspective, there's a lot of things that one could possibly consider problematic about that Frank's memorandum. You know, ethically speaking, it calls a man who's not been charged with anything essentially Charles Manson. So I think, like, on the outside, as people looking at that, is that a responsible thing to do? Some people would say no. But legally speaking, is it a problem? I don't really see how it is. Is it a I say sneaky, but maybe not so sneaky because it's so overt. Is it an overt dodge of the gag order? Yes. Does that matter? Well, I mean, it's filed in the court, and I think the responsible thing would have been to maybe redact some of the alleged odiness that they were smearing. But I don't really think that's necessarily enough to get it taken down.
It's fair to say, in my opinion, behind the scenes, we have talked about the Frank's memorandum amongst ourselves. We've talked about it with a wide variety of people in the community. We've talked about it with professionals. We've talked about it with attorneys.
Art dealers.
We've talked about it with a surprisingly large number of people. And a lot of those people had a lot of criticisms to make about it. Some people liked it, but a lot of people had criticisms.
The vast majority of people did not.
No one that we talked to who made a criticism of that memorandum criticized the fact that it named the murder victims.
No, that was not the big problem with it in anyone's mind. And I really don't think a lot of people we were talking to about it, I think some people found it reprehensible from an ethical standpoint because of some of the things it was doing. I don't think anybody was necessarily saying, and therefore it can't be up there. And in addition to that, I don't know. It just seems like, again, the horse is out of that barn. And also the victims' names, nobody even, I don't think anyone even referenced that. So I don't know, maybe there's some sort of like legal trick that they're trying here where, if that ties into this and therefore the domino effect, but I can't really see what that is at this point.
I don't think it's a strong argument. I think it's frankly a bizarre argument. And if she says that this can't be made public because it mentions the names of the victims, then somebody needs to go through all the earlier filings and prepare redacted versions of those, which just seems to be an enormous waste of time.
Yeah, I mean, like there's sensitive information. I mean, they go into depth on the crime scene, right? I mean, if they're saying
the memorandum,
the memorandum, if they're saying that, well, he's innocent and someone else did this, then, they've basically kind of destroyed any ability to like suss out wrongful confessions because now everybody has a blueprint of what happened. It's like there's things like that where you can maybe squint and see something, but that's not one of them.
The brief concludes by saying, should this court grant a writ to relator, the court will become inundated with petitions alleging that trial courts across the state committed a technical violation of the access to court record rules. Disputes of the type relator raises are best resolved by the ordinary appellate process.
Okay, that makes sense to me. If everyone, if you let somebody cut the line, everyone's going to cut the line.
Yeah. It's
going to be chaos.
And there is a process in place. And certainly that argument might sound better since it just came after that murder victim name argument.
I have a question. Minus the murder victim name argument, how well reasoned do you think this is? What's your assessment of it overall? Minus that one.
They do a good job of citing relevant cases and arguing things quite well. the fact that Richard Allen didn't demonstrate through the attorneys that harm would come to him through this is a valid point. If he's not going to suffer extraordinary harm, if this isn't granted, then why are we rushing to the Supreme Court with it? Why aren't we just doing it at a lower level court?
Yeah, that is a pretty piercing question in my mind. But I guess we'll
With all that said, as we indicated, we fall on the side always of openness and transparency.
I think that things should be done differently going forward. I don't think this is a good way of handling this case, the secrecy. It really needs to stop. I think we've said this, but in the investigative phase of this whole case, the secrecy was frustrating and I think at times misguided, but I think more understandable than it is now because it was not being adjudicated. And, that enough is reason to perhaps keep a lot secret. But when we're getting into the judicial phase of this whole thing, it needs to come out into the sunshine. And I agree with the Indiana Broadcasters Association because it's imperative that the press be able to report on this effectively going forward because there is such a public interest in it. And I just hope that whatever happens here, there is some kind of permanent shift in how this is dealt with because the records are important and it's important that people have confidence that this is being run effectively going forward. And I think this is kind of like this is a red light, like let's stop and fix this before we go forward. So I think it's an opportunity to turn things around on that front.
It will be interesting to see what happens with the court. As we say, there's a second matter before the Supreme Court related more directly to whether Gull, Rosie, and Baldwin should continue on with the case. It'll be interesting to follow that. I believe the briefs on that aren't due until November 27th, so we have time.
Do we have a sense of when exactly the court will make a decision on this recordings writ?
Hopefully soon.
Yeah, there you go. All right, well, thank you all so much for listening. We really appreciate you, and be safe, and we'll talk again soon. Bye.
Thanks so much for listening to the Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.